Just a disclaimer, the opinions expressed in this podcast are our own views and views of our guests. Nothing in this podcast is to be taken as legal advice.
LexisNexis is a proud sponsor of That's Just Criminal podcast. Remember, AI won't replace lawyers, but lawyers using AI will. Make LexisNexis your preferred legal AI research and productivity technology partner. Find out more at lexisnexis.co.nz. The That's Just Criminal podcast is proudly sponsored by the Criminal Bar Association of New Zealand. The CBA was set up in 1984 and provides support and collegiality to criminal practitioners in New Zealand, whether they are defence lawyers, prosecutors, judges, academics or students. For more information visit www.criminalbar.org.nz. Now let's get on with the episode.
Have you told Andy or Jane can edit out swear words and we edit out mansplaining as well? So if you do any mansplaining, it's going to go, so it's going to be a waste of your oxygen.
But I have to say cockbag at one point during the podcast, right?
Kia ora, tēnā koe, and welcome to That's Just Criminal with me, Annabel Cresswell, and my co-host,
Sumudu, Thode. Today's guest is Andrew Hill, or Andy. Andy is a member of the Criminal Bar Association, along with me and Annabel, and he is a lawyer in Rotorua.
Today's topic is about whether we elect trial by jury or trial by judge, and so we've asked for another barrister from a different part of New Zealand who practices to come on and give us his expertise in that area as well, and how he does things.
Andy's been a Crown prosecutor, and he's, just like all our other guests, have worked in London and Wales. He's done about 150 trials in both the District Court and the High Court, so he's well placed to talk about the election to either choose a judge-alone trial or a jury trial. Thanks for being with us, Andy.
Kia ora, guys. My pleasure.
So today's topic is another decision-related episode, and this has been by popular demand. A lot of people really enjoyed our episode on the decision whether to give or call evidence, and have asked us to do one on the decision whether to elect trial by judge or trial by jury. Sumudu, why don't you start by explaining when that election comes up and what it means?
So if you are charged with an offence that carries more than 2 years imprisonment, you can elect to either be tried by a judge or elect to be tried by a jury of 12 peers. This election needs to be made at the point of you entering a not guilty plea, unless, of course, the court gives you leave to elect at a different time. You can also change that election, especially from jury trial to judge-alone trial, and we'll talk about that as well and what goes into our decision-making in terms of changing that election.
And that's why we've got Andy on here today, is to have another third barrister to see we all do it differently, so we can all bring different theories to the party. Once you elect trial by judge, it's very difficult to unelect that and to then decide that you want a jury. And to be very clear, obviously, trial by judge means one judge hears all the evidence against you, and trial by jury means 12 people, members of our community, hear it all. So the decision comes down to, for defence lawyers, what's more likely to be successful for our client. What's your key to making this decision at the point of entering a not guilty plea?
There's a few things that go into it, I think. The nature of the charges is probably one of the biggest ones for me. I don't know about you guys, but my default position for serious domestic violence and sexual offences is always jury trial. I don't always end up at a jury trial with those, but that's certainly the default. So the rule of thumb is to go in that direction. And I have a theory behind that. I'm not sure how watertight it is, but in my view, I just think defendants are going to get a fairer trial with those charges on the table in the jury jurisdiction as opposed to the judge-alone jurisdiction.
I would like to know why you think that.
Well, I think for sexual cases, for example, I feel personally that judges are somewhat cynical, maybe a little tarred by their time in the criminal justice system, and perhaps either consciously or subconsciously a little complainant-centric. Of course, it's different from each judge, But I think the jury jurisdiction just brings in 12 people, obviously strangers. They don't know the person. They don't know the complainant. They come from different walks of life, different life experiences, all of those sorts of things. Uh, They haven't been immersed in the criminal justice system. They don't have the baggage that perhaps judges do. They haven't seen 101 of these cases before.
Don't you think, though, on the other side of that, it's much more shocking for members of the public to listen to sexual violence, whereas we are and judges are all much more hardened to it and used to it. So do you think, though, that jurors are a little bit more horrified by the nature of the charges and then more likely to convict?
Especially if you're talking about charges involving children, I tend to agree. Even just when the charges are read out in court and it's, offending against a child between the ages of such and such, or the descriptions, the particulars are read out. So I agree with Andy in that my default position for charges of that nature is to go jury trial. But I'm now on the fence again, going, actually, is it better that we go judge alone? Because the prejudice alone for our client, even just with the accusations in front of a jury that don't understand the bigger picture, I don't know if that's really helpful to our clients.
I agree 100%, Sumudu, actually. So my default is that, but you have to be cognizant of the individual facts of the case. An educator, I'll call them that, in a religious school where allegations of indecent assault had been made against that person. And we thought long and hard about whether or not we were going to go to a jury trial versus a judge alone, because at the time this person was charged, it was all over the news with the Dilworth scandal with all of the old teachers there. There was the abuse and state and care inquiry. And in the end, we decided it would be better to go to judge alone trial because there was just so much information and prejudice out there in the public realm that another educator in a religious school setting being charged with indecent assaults, I mean, these were relatively minor ones, but still the whole context of it tipped us to go to judge alone.
There is something about what's going on in the media and in the community at the time, because I do have a friend who elects judge alone trial on all sex trials now, which I think is really unusual. I think most lawyers would say, Andy has said, but this friend says, well, since the hashtag #MeToo movement, juries are trying to overcorrect. And so taking the whole believing women, believing complainants, and there's been a lot in the media about victims being allegedly re-traumatized through the process. And so this one person said, look, I don't trust juries anymore. They're desperately trying to overcorrect. But there are some real downsides. And I mentioned this to another colleague recently, and he said, what, before you know what judge you've got? And so that's part of it, is we don't get to pick our judge. And it's a big call leaving such serious allegations to one person, judge or not.
I've had judges commenting on jury trials and verdicts saying, oh, your client should go buy a lotto ticket with that verdict. So comments like that doesn't necessarily make me want to elect judge alone, because I know that my client has got a better outcome from a jury trial.
So that's to clarify, if your client gets found not guilty, the judge implies to the jury, whose decision it has been, this man's been very lucky to get away. Yeah.
Comments like that don't really give me any confidence to go a judge alone, because I know that had I gone judge alone in that particular case, my client would have been found guilty.
Yeah.
Andy, do you have any experiences like that?
Yeah, I hear your pain, Sumudu. Actually, when I was a Crown prosecutor, and it was serious domestic violence charges, and I thought we had a pretty strong case. The judge obviously thought we had a pretty strong case. The jury disagreed and acquitted the defendant on 5 or 6 pretty serious charges. And no propensity applications had been made because he didn't have any relevant previous convictions. But at the end of the trial, this judge said, thank you very much, ladies and gentlemen, for your time and your deliberations. I just thought you should know that defendant X has A, B, C, D, E previous convictions, and goodbye and good luck. So he clearly disagreed with what they were saying, and quite inappropriately
Sent them home
told the
feeling
jury
guilty.
that he had a big long list of previous convictions.
Yeah.
And just
Yeah,
like I thought you were wrong, and just very fairly, I've had a judge who just literally got up and walked away once the verdicts were announced by the four-person ones. Normally there's a thank you for your civic duty and the whole system would fall apart if you're not here. Nothing, just not guilty, not guilty, not guilty. And the judge just got up, swiped himself out of the courtroom and walked off. And everybody's standing there going, oh, thank you. You can go home now.
There is that. There's definitely that judges might be more inclined to find your client not guilty. But there are other charges where judges are better, right? I would say one example is for more technical legal defences, like your drink drivings and things where they're not technically guilty, but they actually are guilty, and a judge is more likely to let that one go than a jury.
Yeah, I'd agree with that. I think the one that came to mind was when you have multiple people in a car or a house or something that gets tipped up and there's firearms or drugs or something illegal found, and the police inevitably just charge everyone that was there.
Yeah, or even walking past at the time.
Technically, the law, as we know in relation to if you're legally in possession of something, is actually a little bit more nuanced and technical than that. And so, whether or not an individual can be shown beyond reasonable doubt to have knowledge of that illegal thing and an ability to exercise control over it. I mean, those nuances of that can potentially be lost on a jury, but won't be lost on a judge. And so if you're left with that factual situation, then thinking long and hard about whether or not judge alone jurisdiction is the better one, in fact.
And if you have the right judge as well, they're more likely to be cynical about police, whereas members of the community might more likely to still have a lot of faith in police and think they'll do their job excellently and to the best of their ability at all times. Judges know that things go badly wrong and police do unlawful searches all the time.
I agree. I think especially when it involves police actions, especially here, I think the public still have this really rosy view of the police. No, they would never beat somebody up. No, they would never do that. No, they would never search somebody without a reason. What did your client do to sort of put the focus on them, put the attention on them? So I think if the factual scenarios like that, a judge is more likely to
overlook the kilo of cocaine in the boot of the car and be like, look, the search is unlawful, so as far as I'm concerned, that doesn't exist. Whereas juries might not be able to do that.
The other biggest thing is, going to a judge alone trial, the judges have to give reasons in their decision. So in terms of appealing something, your client goes to a jury trial, the jury comes back saying guilty, and a lot of the time you're just left wondering, well, was it question 1? Was it question 2? Was it this? Was it that? And then appealing that is really hard because you don't know why the jury came to that decision.
It's just some clients, and these decisions are obviously client decisions at the end of the day, but I've had a few clients who make their election based on the fact that they're going to get a written or oral decision from the judge because they want to know one way or another why they have been found guilty or why the charges haven't been proved.
That's really interesting. I hadn't thought about spending too long on that part of it, but it definitely, the wondering about verdicts sometimes and then trying to explain it to your client afterwards. Well, we don't know why they came to that. And we only get a little bit of a look, like a little peek into why juries come to the verdicts. If we meet someone at a barbecue or on the street and they might occasionally say, oh, you were on my jury and we went not guilty because we just felt sorry for them, or, they might give you a reason like that. That's the only glimpse we get, and that's relatively rare, isn't it?
And that's the thing. But then I had a judge say to me, because I had a conversation with somebody about this recently, they said, look, if you've got a he said, she said type situation, aren't you better to go to a judge alone? Because how do you decide on two equally plausible explanations? Whereas, a jury just literally says guilty or not guilty, whereas a judge still has to go through that process.
Well, but if they're both plausible, then it should weigh in favour of the defendant because
exactly. That's what they were trying to say. I think is if you've got a case where it could go either way, aren't you better to go a judge alone trial rather than going a jury trial, because at least you get reasoning as to, and judges would actually have to go through the evidence.
Yeah, I would agree with that, Sumudu. So I had a trial like that where it was an allegation by a then 16, 17-year-old boy that had been habitually sexually abused and raped by his father over the last 10 years. And just because of the ick and the gross factor, he was really inclined to not have it in front of a jury for those reasons that we discussed earlier. So primarily for that reason, he elected judge alone because it was a he said versus he said situation. And ultimately, the judge did exactly what I'd hoped he would do, look at it and go, look, this is a strong complaint. Maybe it happened. I just can't be sure it happened because I've got a strong denial. He had a police interview and the evidence hasn't got me to the point where I'm sure. And so, great, that worked.
The other thing is obviously what Andy touched on before is that it is the client's decision. So it's similar to what we talked about with the election in terms of clients giving evidence or not. Whether or not you go to judge alone in jury trial is the client's decision. Have you guys had a case where the client's decided one way or the other and you're like, wrong, this is not the election that you should be making?
I have, and it's for pragmatic reasons, which is a bit of an indictment on the length of time things are taking to get to trial. Because when I explain judge alone versus jury trial, you do the basics like we've discussed. But one of the things I also talk about is timing, like judge alone trials. Now, in this jurisdiction, you're probably looking 6 or 7 months out from the date you're charged, sort of thing, around about.
Jury trials, a short trial,
Yeah. Jury trials, 18 months to 2 years. And if you're on restrictive bail conditions or
in custody,
even worse, then I've had clients that say, stuff it, I want to go judge alone just because it's going to take way too long for a jury trial. And I'm sitting there pulling my hair out going, no, this is not a good case for judge alone. And pragmatically, they're like, I don't care. I just want this thing over and done with.
I've had a recent client who's been charged with driving whilst disqualified, and he wants to elect trial by jury. And it's because there's this sort of backstory to do with his ex-partner, and he thinks what we talked about before with the whole Me Too stuff, he thinks that he's not going to get a fair trial because of this child custody arrangement in front of a judge. So he wants to go jury trial on a driving whilst disqualified.
The problem with that, though, is pisses the judges off and uses a lot of resources.
Yeah, absolutely. But ultimately, it is the client's decision. And if they want to elect one way or the other.
Just point the judge to the New Zealand Bill of Rights Act that says it's his right to elect.
And I might be also a little bit scarred from when we were at the Crown, Andy, there was a judge, deceased now, but he used to haul defence counsel into chambers to go, why have you elected on this? It's a minor offence. You should be. And so I've always wanted to avoid that. But it's, you're probably
the judges should be happier. The election used to be 3 months. It's gone up to 2 years.
2 years,
so,
Yeah, that's true. It's just that if you are as experienced with the system as we are and know the backlog and know how long everything takes, it's just, there's more to it than just your rights, your Bill of Rights.
I think the other thing is, there's some clients that if they're part of a gang or they've got facial tattoos or something like that, they tend to think that they're never going to get a fair deal in front of a jury. So I've had a couple of clients who have just gone, look, a jury's going to look at these tattoos and all the gang evidence that, the Crown are going to call or propensity evidence, and they are convinced that they're not going to get a fair trial in front of a jury and want to elect judge alone because of that. What about when you've got, a reluctant witness or, a hearsay application, which seems to be more and more common? What are your thoughts on whether in a situation like that, if a judge alone trial or a jury trial is better?
Oh, I would definitely take those to jury trial just because judges, before they were judges, they were lawyers. So they've had those clients or they've seen those cases. During the time on the bench, they've seen hundreds of other cases. We've all seen them. Stereotypical domestic situation where female complainant makes a complaint on the night. Police come around, take her statement, take the photographs. 6-7 months rolls around and she's reluctant to come to court because they've patched things up or she wants to retract her statement or not come to court.
He's making her.
But the judges see right through that and 9 times out of 10 will convict your client based on what she initially told the police on the night, which is fine. And the law allows it. Hannigan, we all know it, love it. But I think if you're trying to do the best by your client, then the advice should 100% be go to a jury trial, because you have that 12 people, different backgrounds, real world experience. They're not tarred by the justice system. They've probably never heard of this, a type of this case before. And maybe they sit there and think for a second, well, hang on a minute, she's come to court and said something completely different. How can I be sure what she said on the night is right?
Yeah.
One of the other things that happens is you elect jury trial, and then all of a sudden when the file goes to the Crown, there's, 5 new charges added. And I guess this depends partly on the Crown Solicitor's Office and their view and all of that. But, that's something obviously we need to advise our clients on, that the Crown Office may look at this and add charges which are more serious than what they're facing when the file's with the police. Has that happened where it's completely backfired on you? Or not on you, on a client?
Yeah, I've heard horror stories. I mean, I think that goes both ways though. So sometimes the police undercharge, and when you, even on the initial disclosure, and you've had discussions with your client, so you haven't got the full witness statements or photographs or medical evidence, but you've got the summary facts and the charges, and you discuss it with them, and they're nodding along going, yeah, that happened. And you look at the charge and go, well, that's a pretty good level of charge. I'd be pleading guilty straight away if I were you. But alternatively, if the police are being a stick in the mud about something, and they're not willing to move or negotiate on anything, and there is an election because, the charge is serious enough, and I don't see that it's going to get any worse, it can only get better if a fresh set of eyes looks at it, then I'll say, we're not having much luck with the police, let's try a different avenue and we'll go to the Crown. And maybe we don't have much luck there either, but at least there's a possibility of getting a better answer.
And I think that's something as well to explain to those who don't do this job. Once you elect trial by jury, it goes to the Crown, who are a firm of lawyers. And often for those smaller charges, they'll otherwise remain with the police, who are not as experienced in charging. So sometimes when you look at it and you can go, this is really badly charged. If a Crown prosecutor looks at this, they're going to realise they don't have the evidence, and they might either withdraw it or be reasonable and lower the charge or whatever. So sometimes it can be an idea to elect for that, because you just want a lawyer to look at it. But it can go the other way, because if you get a really zealous Crown prosecutor, they can add in some extra charges too. So that's a massive risk, because you're actually, once you get found guilty by a jury, because you're in a higher jurisdiction, technically you're meant to get a more serious penalty at the end of a jury trial, aren't you? Because I've heard judges say stuff like, you've elected trial by jury, you play with the big boys now.
Yeah, I think there's probably an old school sentiment along those lines. I'm almost certain there's nothing in the Sentencing Act that says that, but I think you will run up against that. You've wasted the court's time, you've taken it up here, so you're going to get a little bit more of a sterner sentence. But I don't think that's anything in the purposes or principles of sentencing.
Another thing I think people might be interested in is the jury pool. Don't know if people realise that the Crown get 4 challenges when the jury are called, and the defence get 4 challenges. And jurors often seem quite bewildered when they get challenged before they go in the box. They don't get chosen for the jury. What's your guys' process for how you choose a jury, or how you exercise those 4 challenges that you get?
Most of my trials, like my learning to do trials, I was a Crown lawyer, and the Crown would always, I'm not sure if they do now, but they would always get an expanded list of the jury pool that had been vetted by the police. And so we would get lines through certain people's names that should not be allowed onto the jury. We weren't necessarily told why, but it was primarily because they had previous convictions or negative interactions with the police, and they were deemed to be unsuitable to sit on the jury just because they were more inclined to be anti-establishment and likely to let people off.
Yeah, or if they're like sex offenders, they might also think that there's nothing wrong with sex offending, for example.
Yeah, absolutely. I had a fraud trial actually when I was a Crown lawyer, and the foreperson who was elected changed their mind and said that they couldn't do it for whatever reason, so we had to get another jury member on. I had run out of challenges by that point, and a multiple convicted fraudster from Australia who'd been deported back to New Zealand got onto the jury. and then was actually the foreperson of that trial.
Oh, really? And you knew it, and you could do nothing
And I
about
couldn't
it.
do anything about it.
Can you remember whether they convicted or not?
We got home on most of the stuff, so that was fine. But yeah, me and the OC at the time were like banging our heads
Just-
against the wall, going, "What the heck?"
Yeah.
But from the flip side, the defence side of things, I had always been told, from more senior defence counsel, that you definitely don't want teachers on your juries, and you definitely don't want nurses or anyone that is potentially
In
sympathetic
a caring profession.
carer role.
Yeah.
Because they're far more likely to put themselves in the complainant's shoes and accept what they're saying without critical analysis. That's the theory.
I don't agree with that. I used to do that too, and I was taught that way too, but I don't agree. I think anyone, doctors and nurses and engineers as well, are really analytical. Anyone who's educated and scientific is analytical, and that's exactly who you want on the jury because they like evidence. So I do let doctors on. Teachers, not sure.
Yeah, like at a child.
Depends on the
sex
charges,
case,
though.
Yeah.
Yeah.
I wouldn't let a teacher on. But I'm with you,
Yeah.
Annabelle. Like, I'd heard that theory and I was like, really? I'm not sure if that really holds water.
Yeah. Agreed.
I guess it depends, though, because, if you've got a child sex complainant, you probably don't want a teacher. If I was doing a trial like that, I would challenge most of the teachers. But then at the same time, say, if it is a sexual violence case and I know that there's sort of ESR evidence or something coming in, I'm probably like, yeah, let a nurse in. They can explain the lack of evidence, and if we're making something of it, or, the lack of DNA or something like that, I'm like, yeah, let's have a doctor or let's have a nurse. But the problem is, I think if you are in a role like that, a lot of the time you get excused from jury duty.
My main thing that I say when I'm teaching juniors or when I'm, doing a trial with someone I haven't done a trial with before and they go, what's our selection process? I usually say, just keep it a mix, because the more different people, different ages, different backgrounds, the less likely they are to agree. And when you're defence, you just need them to not agree. That's all you need. That's the only kind of thing I do now, is just try and keep it mixed up. But I do think in Auckland, we get a lot of students. And I think students are really good on a jury, and international students also bring, I think, a different approach to things, and often everyone can't agree. But that's just my current theory.
Yeah, I'd agree. Diversity is key. I mean, that's one of the main reasons you tell them to elect jury in the first place, because judges, be they male or female, they're going to be middle-aged, they're going to be educated. And so they have a worldview, don't they? Which is their own worldview, but it's not necessarily the same. In fact, it's not going to be the same as 12 people on the jury from diverse backgrounds. And so,
Yeah.
you want that mix.
You can also guess at people's politics by their addresses. That's the only reason I look at it in Auckland. Like if they're from Greyland or something, it's a good chance they're like a Green voting, someone we do want on our jury, sympathetic, empathetic.
I get a bit troubled when people are really energetic to get on the jury panel as well.
The gallopers.
They're in the
Yeah,
public
the
gallery,
gallopers.
and their name gets called out of the ballot, and they just bolt up like this is the best thing they've ever done.
Sit
You're
down.
like, no, challenge. Yeah.
Yeah.
Absolutely. We always challenge the gallopers.
The gallopers are always the ones who come out first thing with a question or with, I've checked this on the internet. And
Actually, speaking of that, obviously the juries are told not to go and research things on the internet, and the law's been changed about this as well. But have you had experiences where or a jury's been discharged, or there's an issue that's come about because a jury member's gone and researched something online?
well, there was one here, a famous one. It was a High Court trial got aborted, didn't it? Because a juror had Googled the complainants or something like that, and then came back and told all the jurors what he'd found. So they had to.
There was a local judge who changed his direction actually to the juries over the years, because he used to give them the standard one. Don't do your own research. It's really important you just stick to the evidence in the court. And there was a case where he had to discharge a jury because someone did their own research. They had printed a whole bunch of stuff off Google, put it into the jury room, started discussing it with all the rest of it. And it only got found out by the jury assistant, the court taker. No one on the jury reported it. And he found out at one of the breaks. And so he called them all in and said, "Why didn't you guys tell me?" And one or two of them put their hands up and said, "Oh, we knew it was wrong, but we didn't know what to do about it."
Yeah, so
So
now
he
he tells
dismissed
them.
that jury, and then
Yeah.
from then on, basically made the foreperson be the narc, and
Yeah.
said, if anyone brings in material that they shouldn't have, it's your responsibility, Madam Foreperson or Mr. Foreperson, to come and tell me straight away.
Yeah, that's good. And have you guys read Dice, the book that was written about jury trials in Juror, but written by Claire Bayliss, who did a study of juries? It's actually a really good read for defence lawyers.
Well, we had one in Rotorua a few years ago. It was a big headhunters trial. There's 6 or 7, big burly tattooed gang members on trial for some reasonably serious assaults on someone. Trial that went on for 6 or 7 weeks. They'd kidnapped him and, beat him and tortured him and extorted him over the course of 3 or 4 days. And this jury trial, and 3 or 4 of the jury members were young women, probably 18 to 23 or 24. And it was completely obvious over the course of the trial that at least a couple of them started getting really infatuated with these big burly gang members.
How would that become obvious though?
Oh,
How do you
Because
know?
of winking and smiling and all sorts. And I mean, they were acquitted, not because of that, I don't think, but maybe the
Could
evidence
be.
wasn't as strong. But there was some very strong suspicions that they weren't really listening to the evidence. They were just looking at their favourite gang member.
There was one in an out-of-town court where a juror passed a note to the male Crown prosecutor asking him out, but had it passed to him and so again, I don't know if it's worth it aborting the trial because I would say they're not listening or they're going to be biased towards the Crown case. So I'd want to
I
check the
had-
trial.
In my prosecution experience, should I feel offended?
It never will, Ed.
I once had a jury member afterwards had sent me a Facebook friend request,
Gross.
which was really, obviously didn't accept. But I was just like, my client was still found guilty.
I had a juror move in next door to me. He's still my neighbour now.
Did you ask him why he came to the verdict that he did?
Yeah, it was a good verdict for us, so I was quite happy.
Oh yeah, but did you still ask? And did you get any feedback?
Yeah, no, it was for context, it was a bar fight at the Okarori pub, which is sort of a rural pub where a lot of farmers go to, and it was a
That's
pool
awesome.
competition
Yeah.
gone wrong. They'd all been drinking all night, and it just turned into the Wild West. Pool sticks, beer mugs, 6 or 7 different people smacking the heck out of each other. And in the end, he just thought that it was a bunch of cowcockies drunk too much booze and punched each other over. And so they acquitted our 3 defendants on all the serious stuff and convicted them, I think, of 2 minor assaults. And he just thought it was funny. The whole thing was hilarious. It was a week-long trial, and he just thought, yeah, well, it's just farmers being farmers, isn't it?
I mean, that's not the analysis that we sort of want our jurors to go through. But if it gets you to the verdict that you get to, and that is a good example of how random it is. We can spend all this time trying to be scientific, trying to prove our or unprove our case, and they just go, "Oh, but farmers, isn't it?"
But they had given all the defendants. So there was 3 defendants and, I don't know, 6 or 7, other witnesses at the Crown Court. They gave everyone nicknames. So everyone obviously
really?
had their legal name, but they were giving them all these. I won't tell you, but my client started with a B, so they called him Basham B, because he had clobbed someone over the head with a glass
it's
stein.
not helpful to you. That's not helpful.
But he was still found not guilty.
Did
the main stuff.
Did they give the lawyers nicknames? I would pay so
Yeah,
much
maybe.
money to know what yours was.
It was a self-defense case, Sumudu, so that everyone was fighting everyone.
Yeah.
That's the thing. I always wonder what the jurors think about the lawyers as well.
You do get some indications, though, Sumudu, as you know, when you're doing your closing address and you're staring at the jury and trying to connect with each and every one of them about, why they should acquit your client. And you have to skip over some people because they're just looking back at you going, shut up. Stop talking to me.
Or refusing to look at you. That's the hard one when you try desperately to get eye contact and they don't.
Or just like scoffing every time you say something. Like,
Yeah, or sniggering or laughing. Or it's worse when they're just mumbling and agreeing with everything the Crown says. Then you know.
So I heard this, and I don't know if this is true or not, but a case in Auckland where before the Crown closed, the jury had passed a note saying, do we have to listen to the Crown prosecutor's closing?
Yeah. Yeah.
And I was like, oh, but apparently they still found this person guilty. So I was like, well, imagine being, the lawyer when they're like, do we have to listen to you? Honestly, do we have to listen to you? And you just have to get up and go, sit down. You do have to listen to me.
Take it as a challenge, Sumudu. You can really convert them back to your way of thinking if you do a persuasive and powerful closing.
True. Yeah. At least if you can get a hung jury.
I don't know if you guys do, but I do police association work. So this is where police officers, in the course of their duty, have been charged with criminal offences. And so they have an association, I guess like a union, who pays lawyers like me to represent them. And I've done, a few of these over the years, and always, bar one, I go to a jury, because I think even if their conduct is demonstrably criminal, juries just have a hard time personally convicting active police officers for anything in the course of their conduct, in the course of their duty.
Yeah.
I think it depends on what they've done. And if the Crown are able to show, like you say, this is the bad apple in an otherwise upstanding profession, then that could go the other way.
It's normally excessive force. So you're arresting someone or you're chasing someone and they've either resisting a little bit or not much, and the police officer's just taken it too far. They've handcuffed them and then they've thrown them into the car and punched them a few times or hit the head on the car door or whatever it is. It's normally excessive force. And in my opinion, most jury members just shrug their shoulders and say, so what? I'm not convicting this guy of excessive force. He's just doing his job, catching a rat bag. No way.
And the rat bag probably deserved it.
Whereas a judge would have to be more technical and go, that probably was excessive force. You didn't need to do that. He was handcuffed. He wasn't a threat to you.
Yeah.
I think with juries, it's just like, I always just kind of go, have I got a story to tell? I feel like it's better in front of a jury. And, there's the theatrics of it and there's sort of all of that we play on. Whereas if it's a technical, it all falls on question one, or the definition of recklessness, then I think judge alone is better. I mean, I have to be honest, my go-to in these serious stuff is to go jury trial. But now I'm thinking, I don't know, now I'm thinking whether I need to rethink my stance on some of these, or at least closer to trial. Once we know the lay of the land. Once you know the lay of the land.
Yeah, that should be a change of circumstances. They should change the legislation. Change of circumstances includes finding out who your judges go to.
So the first episode, we talked about how the election is a really crucial decision in the trial process. And I guess this is one of the really crucial decisions before we even get to the trial process in terms of what path you're going to go down. Thanks, Andy, for hanging out with us tonight and having a couple of bevies. We really appreciate your time and the war stories that you've told us.
My pleasure.
Will you come back?
No, never.
Can we talk about his voice while he's here?
No.
Rather than after he.
Annabel, I'm really disappointed. Like, I listened to your last podcast and you introduced the guest as like dreamy or really good looking or something like that.
I know you very well and it's all worn off, but Richie was like, I just Googled him and was taken by surprise.
Lucky it's a podcast, eh? Not a lot of video cast.
Yeah.
Am I done? Am I released? Edit me kindly, Jane.
Thank you very much for coming on, Andy. And thanks to the Criminal Bar Association and LexisNexis for this episode of That's Just Criminal.
Make sure you subscribe wherever you listen to your podcasts.